Our last chapter will look at international business in a global economy. There are several sources of international law. It's based on international custom treaties, organizations that govern relationships between nations. Um, there are bilateral and multilateral agreements between nations and international organizations who are mainly composed of representatives from member nations. Usually this is established by treaty. One important principle is the principle of comity. One nation will give deference and effect to the laws and judicial decrees of another country, as long as those laws and judicial decrees are consistent with the law and public policy of the accommodating nation. The Act of State Doctrine says the judicial branch of one country will not examine the validity of the public acts by a foreign government within its own territory. A doctrine may immunize a foreign government. When a foreign government takes private property, it can do it rightfully or wrongfully. Rightfully would be expropriation, which is compensation to the foreign firm. Confiscation would be taking the foreign firm without compensation. There's the doctrine of sovereign immunity that exempts foreign nations from jurisdiction in U.S. courts. However, a foreign state is not immune from U.S. jurisdiction when the foreign state has waived its immunity, has engaged in commercial activity within or outside the United States that has direct effect on the United States, or when a foreign state has committed a tort in the U.S. or violated certain international laws. One question that comes up is what is actually considered commercial activity. There's several ways a business can do business internationally. One is through exporting, establishing distributorships in foreign countries, or entering into distribution agreements with terms and conditions, or actually manufacture abroad. By licensing, which involves usually intellectual property or trade secrets, or having a wholly owned subsidiary or a joint venture. Regulation of specific business activities. Certainly, expropriation is a major concern. If you invest overseas and that government seizes your assets, there's also import controls in terms of quotas, amount of goods that can be imported, or tariffs, which are taxes upon imports, political factors, anti-dumping duties, where another country dumps a product in United States at less than what the U.S. can produce. There are efforts in a lot of different areas to minimize trade barriers, and one issue that comes up is bribing foreign officials, which has been kind of an unspoken way of doing business, but lately it's caused global corporations to have issues, both ethical and legal. Commercial contracts in an international setting, there's certain clauses to take a look at, which country's language to use, where disputes would be settled, under what law, or what's called a force majeure clause, where it's impossible to fulfill the contract due to some act of God, natural disaster, and also some provision regarding civil dispute resolution. There are different issues in international transactions in terms of payment, different monetary systems, foreign exchange, obviously, but then there's correspondent banks and a letter of credit. You should take a look at that diagram that's in your chapter in terms of how letter of credit works. One issue that comes up is whether U.S. laws apply to other nations' businesses. Certainly, if a U.S. corporation goes overseas, it should apply to them. It shouldn't be able to escape things like discrimination laws by going somewhere else. International tort claims often involve human rights issues. U.S. antitrust laws apply if a foreign conspiracy has a substantial effect on U.S. commerce.